case. Where are all the lawyers on there?
Lawson, Sinis Dramas Law Firm, Dale Robinson, which is Sullivan, Ward, Patton, Gleason, and Pelty. Juliana Sabatini and Paul Robinson.
Got it. That's the one I was. All right, looks like we have all counsel connected at this time. We'll go on the record in Keeley versus Napa Auto Parts, case number 2211146. If I could just have counsel put your appearances on the record, starting with the plaintiff. Mr. Lawson, you're muted.
Can you hear me now?
Yes.
Brian Lawson for plaintiff Melvin Keeley.
Dale Robinson for Napa.
Good afternoon, Your Honor. Juliana Sabatini on behalf of the cross defendant Apache.
All right, thank you. We're on the record today for purposes of a status conference. I think the last time we met was for motion hearings. I think that was either June or July. So this is more or less a check in with the parties to see if we need to set anything for scheduling going forward and to see where everybody's at. So Mr. Lawson, on behalf of the plaintiff, could you speak to that first?
Yeah, Your Honor, we've taken some more depositions, and I think the story of the case is becoming pretty clear. I have asked both Mr. Robinson and Ms. Sabatini if they would agree that Ms. Sabatini really has no place left in the lawsuit. She's not a defendant of mine. Her only role is in a potential indemnitor to Dale's client. That issue presumably would be tried separately from my client's claim for personal injuries. At least it's always been that way for me in the past. I think Dale agrees. Juliana has not disagreed. She just hasn't gotten a response from her client at this point. So I've prepared a motion. I'm holding off filing it until I hear from Juliana, hopefully tomorrow, whether we can make agreement of that. But our position is that Juliana and Apache, they have no responsibility for my client's injuries. The only question at their end is who's going to pay, which insurance company is going to pay. So I feel like, this is a pretty simple situation. Other than that, discovery hasn't been the fastest discovery in my career, but everyone's cooperating well. I think everybody's getting along. It's just different cities getting things planned. We have a couple of more, another DEP or two planned. I want to take the IME doctor from the workers' comp case. He pushed back on that. We finally got it scheduled, but it didn't work for Dale, so we've got to reschedule that. And I believe Dale is going to take my economic expert in a discovery DEP too. Meanwhile, Dale and I have talked, and Juliana and I talked today, and I think everyone's in agreement that a mediation or facilitation would be good in this case. We've already started talking mediators, and it may be helpful, I don't know, for Dale's client or Juliana's client, as it sometimes is, if you would order it, rather than them just recommending it to their clients. I know my client is happy to facilitate. We're always happy to go if we think it's going to be meaningful. I have asked Dale to make sure that he's not going to show up with, $5,000 or $20,000. I made a demand in this case. We've provided an economic loss report, which is in the just south of $1 million. So I'm happy to facilitate as long as everybody understands that I don't want it to be a waste of time, which, I think is true for everybody.
All right, thank you. Mr. Robinson?
Yes, I would agree, Your Honor. I think the issues are separate between the plaintiff and my client, and then my client and Apache. I think that those obviously would not be tried together. Apache has no direct liability to the plaintiff for trial. So I think that would be a separate action. I also agree with the thoughts of plaintiff's counsel on facilitation. My client, who is actually the same insurer that Juliana has, because they're insuring Napa under Apache's agreement with Napa, The claims rep has indicated to me that she would be open to a facilitation and would come there with the authority to settle at a number, whether or not that's a number that plaintiff would like or not like, I don't know. But at least she would be there to participate and not simply come there and say, well, it's not our money, it's their money. So I think the facilitation, I know we're only in October, but we always end up running into November and December and facilitator dates and all that kind of stuff. So maybe a facilitation early in the new year. And then after that, that gives us time to get these steps done. I know council mentioned Dr. Burkhart is only available on Thursdays. He's in Battle Creek. I'm in Detroit. Mr. Lawson's in Grand Rapids. Juliana's in the Detroit area. And he does early morning depositions on Thursdays. I'm kind of booked up my Thursdays until almost right up to Thanksgiving. And then I have vacation and then a short trial in December. So I think giving us time to get Dr. Burkhart done, I want to take the plaintiff's economist deposition, and then plaintiff is also having the records reviewed by Dr. Bloom out of Ann Arbor. Once he has an opinion, then we want to take his deposition. So maybe facilitation by January, February, and then we could revisit it with a status conference, late February, early March or something like that, and figure out if we're going to resolve this or we're not going to resolve this.
Okay, thank you. Ms. Sabatini, anything you wanted to add?
Just on the one issue, well, first, Your Honor, I'm not necessarily opposed to facilitation. I did discuss that with Mr. Lawson earlier today, and I think, I think for efficiency purposes, I think that's probably the way to go. And just to chime in with what Mr. Robinson said, probably toward the beginning of the first of the year makes sense given the upcoming holidays. The only other thing I would add for the court is with regard to severing of the claim that Mr. Lawson had reached out to me about. I can't really make a decision at this point. I haven't discussed that with my clients. And then I would reach back out to Mr. Lawson. I told him after that discussion, and I may need to see his briefing on that because I'm not sure, what he's basing that on. The cross claim is obviously joined with the underlying case currently. So I indicated to Mr. Lawson I would further discuss that with him either tomorrow or early next week.
Okay. Okay, so let's do this. The court will order that discovery remain open for 120 days. The court will order that the parties participate in mediation within that time. I'll ask the parties to confer and agree on a mediator and notify the court in writing of your selection within the next 30 days. And then I would set it for a status conference at about that 120-day mark. I'll leave the issue of Ms. Sabatini's side of this up to counsel for now. Mr. Lawson, obviously, if there's a motion needed, then you can file that at any time and get that notice for hearing, and we can get that issue resolved if there isn't an agreement by the parties. Mr. Lawson, any objection to that time frame?
No, Your Honor, and Juliana and I talked today about this, and we are in agreement, but I'd be curious about Dale's response. I think even if Apache is excluded from this lawsuit moving forward, and I will file a motion if Julie and I can't agree, I'll file it right away. What's turned out is Apache's getting two attorneys, or Genuine's getting two attorneys to ask questions at every dep. And it doesn't make any sense. I mean, they should get one person to defend them, and that's it, not two. If Apache wants to defend the case, they should assume the defense and have Juliana do it, but they don't get two cracks at the apple at every dep. That being said, at facilitation, I don't mind Apache being there. As I understand it, it's still only one insurance company involved, but Juliana and I talked about her client being there. That's fine with me. More people, the merrier, I guess, for facilitation. Other than that, everything you said, I agree with. And I think that's a good plan.
Okay, thank you. Mr. Robinson, do you have any objection?
No, I do not, Your Honor.
Okay, Ms. Sabatini?
Your Honor, quite frankly, I really don't want to necessarily be at the depositions or ask questions, but the claims right now, as I indicated to the court, are joined and they haven't been severed. So I think at least in the next week or so, there aren't any depositions scheduled. So I'm hoping that Mr. Lawson and I can discuss that before there's any more depositions on the books.
Okay. All right, so I will put those dates into an order. I'll get that out to the parties, as well as the date and time for that status conference. And we'll go from there. Thank you. That's all I have for today, and all parties are free to disconnect at this time.
Thanks, Your Honor.
Thank you, Your Honor. Thanks.
Thank you, Your
everyone.
Honor.
Bye, guys.
Take care.
Okay, we've got everybody connected. We'll go on the record in Schultz versus Clay, case number 2211257. If I could have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Joshua Williams appearing on behalf of the plaintiff.
Adam Byrne on behalf of the defendants, Julie Clay and Bonan Masek are both present here in my office.
All right, thank you. We're on the record here today for purposes of a status conference in this case. So Mr. Williams, on behalf of plaintiffs, can you tell me where things are at and what kind of dates you would like to request or action you'd like to request from the court going forward to get to a final resolution?
Well, Your Honor, the defendants have, after we held mediation, they tendered over a proposal as far as the settlement on this. My clients are ready to resolve. However, we just have an issue with the terms. So we had submitted earlier this week to the defendants our amended terms to our version of the proposal. An agreement as far as settling this is wanted, I believe, by both parties. It's just the terms as far as which terms we can agree on.
All right, Mr. Vernon.
So we have received their counter proposal. We are reviewing it. There are some terms that we are going to have a conversation about. At this point, we don't have an agreement. What I would suggest to the court is that we schedule a date for motions for any motions in limine or motions for summary disposition, and then schedule a trial date. If we reach an agreement, then we can put that on the record and take those dates off. But I think at this point, it's probably appropriate to start scheduling dates.
I would agree.
Okay. All right, Mr. Williams, in terms of dispositive motions, how much time would you like from today for the court to set as a deadline for having any of those filed and heard?
Your Honor, I don't recall, was discovery cut off for today or was it a later date than today?
Well, we originally set discovery for 180 days at a status conference last January. So that would have been, June, July. And so, yeah, I mean, we're well past that point that we originally set. Nobody's extended that. I think, my recollection is the parties were, and I think still are, trying to work towards a resolution here. So I don't think anybody was particularly concerned when we had our last status conference about the extending discovery formally. So, I mean, that's
understood. Given that, I would say I'm open to, mutually grabbing this date with defense, but I'd say 45 to 60 days around that time period, anywhere from 30 to 60 days. 30 is a little tight, but anywhere in that period.
All right, Mr. Vernon, if we set a motion, a dispositive motion cut off for 60 days, do you have any objection to that?
I don't. With regard to discovery, I mean, we have sent some discovery over to them. I didn't hear any objections to that. I assumed that those were being responded to. There was nothing objecting to them or, communication suggesting they weren't going to answer that discovery. So I'm expecting those answers. But the 45 days for motions will be fine.
Can you say that last part? You didn't come through real clear there.
Sorry, the last part was 45 days for motions would be fine.
Okay. All right, and then Mr. Williams, is this, this is not a jury matter, right? This is gonna be a bench trial?
I do not recall certainly, but I believe it is a bench, Your Honor.
Mr. Vernon, on that issue, do you agree?
Yeah, we did not request, nor will we request a jury trial.
And nor will.
And so, Mr. Williams, how much time do you think would be necessary for the court to set aside for a trial in this matter?
Let me bring my calendar up, Your Honor.
I'm not asking for how long from now, but how many days of
I would say 30 days after the date that we set for dispositive motions or any motions or pre-trial motions or trial motions.
Okay, but how much time do I need to set aside for the trial itself?
Oh, I apologize. I misheard you. No more than 2 days and likely one, but maybe if there were additional witnesses or to be called in, I couldn't imagine there being more than 2 days.
Okay, Mr. Vernon?
I'm not sure what witnesses he's going to call, but I can't imagine it would be more than 2 days.
Okay. Okay, so what we're gonna do is we'll set, the court will put in the status conference order that any dispositive motions are to be filed within the next 60 days. The court will also set it for a status conference at that time. The court will put this on the trial list for a 2-day bench trial. And I think realistically, from today, probably at least 90 days, maybe 120 days before the court will be able to accommodate a trial date in this case. So we'll have plenty of time to have those motions heard, get decisions on that, and then if the parties aren't able to settle, we'll be able to go forward with bench trial to get it resolved. Mr. Williams, any other dates or issues I can address for your side today?
Nothing further at this time, Your Honor.
Mr. Vernon, anything further from your side?
No.
Okay, I'll put this out, order out to the parties and we'll go from there. Thank you. All parties on this case are free to disconnect at this time.
Thank you, Your Honor. Have a good afternoon.
Thank you. Okay, ma'am on the iPhone, can you unmute and tell me your name, please?
Katie Coppernoll.
It's Coppernoll. Okay, great, thank you.
Yep.
All right, we're on the record now in Coppernoll versus Petrosino. This is case number 2311369. You have counsel put your appearances on, starting with plaintiff.
Thank you, Your Honor. Jason Thompson, attorney for plaintiff Katie Coppernoll.
Your Honor, David Leonardson. I'm in here for the defendant, Ms. Pacino.
All right, thank you. This is set for, I believe, the scheduling conference in this case today. Mr. Thompson, on behalf of plaintiff, have we had a pretrial conference yet in this case? I couldn't find anything in the file.
Yeah, we had a first pretrial conference where we agreed that we would go to a mediation. We did that. We actually had 2 sessions. We concluded the second session yesterday. I don't know if the court received the mediation status report, but no agreement was reached. And so it's still the situation that we have the 2 owners on this house, one residing there, one not residing there. We do not have an agreement on how ongoing expenses should be divided. And we do not have an agreement on how to resolve this. So we're going to be looking for the property to be sold. We can address that today. I can file a motion in that regard. We'd like to get on the trial docket. I understand there's a counter complaint from the defendant for reimbursement of expenses related to the property. And I think we could handle most of that at either by motion or by a bench trial. From our position, we don't believe there's any avenue available other than a sale in this case.
How much time would you want to have the court set for filing of any kind of dispositive motions?
If the court was inclined, I would be filing a dispositive motion soon on this, Your Honor, again, to seek that relief of a sale. So whether it's 14 or 30 days, I will have that filed soon.
Okay, thank you. Mr. Leonardson?
I agree with what was said so far. I would suggest that it be 30 days. There needs to be a market analysis by a qualified agent or a real estate agent. And my client has asked that she has possession of the property, and it's our position she has a larger ownership in the property itself. We would ask that she is able to pick the real estate company and agent for their market analysis. We believe that the price will come in at $129,900 or to $139,900. But we need that information before we have a hearing in front of the judge.
All right, so I'll set a dispositive motion cutoff for 60 days. So that should be enough time for the parties.
Yes, we would agree.
Okay, and if no motions are filed, the court will set it for a status conference at about 60 days. I would like to have any of those dispositive motions heard and ruled upon before I set any kind of trial dates, just to make sure that I don't want to set dates that aren't going to be necessary and jam up the docket. So I'd like to have those heard first. So we'll do that within the next 60 days. And if there are any claims remaining at that point, then we can set that to get resolved by trial. Mr. Thompson, any objection to that going forward?
No, Your Honor. And in response to Mr. Leonardson, I mean, we certainly don't object to him obtaining a market analysis, as he indicated they are in possession of the property. So I don't think there's any logistical hurdles to him and his client doing that. And so I understand the court's position, and we'll get that motion filed.
Thank you. Mr. Leonardson, any objection to that plan going forward?
No, we're satisfied with that, Your Honor.
Okay, thank you. I'll put that into an order that'll go out to the parties, and that's all I have for today. All parties in this case are free to disconnect. Thank you.
Thank you.
Thank you, Your Honor.
Mr. Thompson, if you want to stay on, I know you have the 2 o'clock, and your client, I believe, I don't see your client yet, but I'll put you in the waiting room if you want to stay connected.
Thank you, Your Honor.
Happy birthday.
All right, whoever's connected under Zoom user, can you turn on your video and your audio, please? We have somebody connected under Zoom user. I need you to unmute and turn on your video, please. All right, Mr. Thompson, I'm not sure who this person is that's joined. There isn't a name on it, and they aren't unmuting or turning their camera on. So I don't know. Have you had contact with your client? Have you confirmed that he's going to be present today?
Your Honor, I don't know that this got, I don't know. I would request an adjournment at this point. I'm not sure that he's here today, and I quite frankly need that an adjournment on this.
Okay, objection.
No.
Okay. All right, the court will just adjourn the hearing for today. Mr. Thompson, I will request that once you get a hold of your client, if you can renotice this for hearing, then please.
I will renotice this and serve the parties. Thank you very much, Your Honor. I appreciate it.
Okay, thank you.
Oh,
All right, sir, can you unmute, please?
Yeah, I'm unmuted.
Okay, thank you. Can you tell me your name?
Robert Krebs.
Mr. Krebs, okay. 1 second. Whoever's joining us on the phone with the last 4 digits, 0698, can you tell me your name, please?
Yes, Mildred Scott.
That's Scott, okay. Mr.
I
Krebs,
tried to link into Zoom.
Mr.
I'm
Krebs,
sorry,
I'm
Your
gonna
Honor.
make you hold here for just a minute, okay?
Okay.
Okay. Yep.
All right, Miss Scott, are you there?
Yes, I'm here.
1 second. Okay, ma'am, are you Pauline?
Yes, I am.
Is Mildred on the line as well?
Yeah, I'm here.
All right. Okay, we're on the record in Scott versus Scott. This is case number 2311426. Both parties are present by Zoom video here today. This is a divorce action. And let's see. The purpose of this hearing today is for the court to determine whether or not there are any agreements between the parties or whether the court has to set this for a hearing to make decisions on how to divide up any property or assets or debts of the marriage. So Pauline, you're the filing party here. Are there any assets or debts that need to be divided by the court, or have you been able to reach agreements with Mildred?
I feel that we've been able to reach agreements. We don't own anything together, so
Okay, Mildred, were you able to hear that?
Well, Your Honor, I don't feel we've reached an agreement because my wife has chosen to run off out of state for over a month and not decide to speak to me. She has refused to answer her telephone. Her mail is stacking up, and my wife refuses to talk to me to try to reconcile anything.
Okay, well, that's between the two of you. My only role in this case is to decide any disputes you have about how to divide up any assets or debts of the marriage.
Okay, well, I do have a question on that, Your Honor. I'm not sure if it's going to be concerning anything in the future. My wife did report to Social Security that she did do a name change. However, she did fail to report to the DMV, which it has not been legally documented of her name change. Therefore, Social Security has not removed any of her money for the last year. And I would like to make sure that I'm not going to be responsible for paying that back if it catches up to her.
All right, again, that's not really an issue that I would be deciding in this case. Is there any property that you own together or debts that you've entered into together that need to be divided up?
Okay. I just want to make sure it's documented in there so Social Security does come back to me for that money, that it's documented on the court.
Okay. Are there any assets or debts between that
No.
are shared by the two of you that need to be divided?
No.
Okay.
I had
Right.
emotional attachment to the dog, but that's all right.
Okay, so what I'm gonna do is set this for a final hearing where the court will finalize the divorce. Pauline, as the
Yes.
party that filed in this case, there's a final form. It's called a judgment of divorce. And that's a document or a form that you need to obtain. You can get that online. There's multiple places where you can find that. But you'll need to get that document or print that offline. Fill that
document,
out.
it's called document of divorce,
It's called a judgment of divorce.
judgment of divorce.
Correct.
Okay.
And you'll need to print that out, fill it out, and turn it into the clerk's office before that next hearing date, because I can't finalize the divorce until you turn that document in, okay?
Okay,
So I'll need you to do that prior to the next hearing date. Both of you will get the date and time of that final hearing in the mail, just like you did for today's hearing.
okay,
So once you know that date and time, then you know that's the date and time that you need to have that document in prior to that, okay?
okay,
And then if that's turned in ahead of time, then when we're here at that next hearing, I can finalize the divorce. Pauline, do you have any questions about that?
no, that's pretty much it.
Mildred, do you have any questions for me on that at all?
Yeah, I'd like to know when that hearing's gonna be, because I'd like to know how much longer my life's gonna be destroyed.
So I can't give you that date today, but like I said, the court will send that to you in the next couple days. You'll get notice of the date and time of the hearing in the mail.
Okay, I just have one question for my wife. Are you happy?
All right, you know what? We're on the record. We're
I
in court.
need
Now
to ask
ma'am,
her
yes,
if she's
now
gonna,
ma'am, now is not the time for you to engage in personal conversations. You're gonna have to do that outside of my time. That's all we have for the hearing today. All parties are free to disconnect at this time.
Thank you.
Ma'am, can you unmute, please?
Okay, I think we're all set.
Thank you. Can you tell me your name?
Cynthia K. Krebs.
Ms. Krebs, okay.
Mhm.
Okay, and we have Mr. Krebs connected as well, so we'll go on the record in Krebs versus Krebs. This is case number 2311452. The record should reflect both parties are present today by Zoom video. The purpose of this hearing today is for the court to determine what we need to do for scheduling to go forward with the case. The first question that I have is whether or not there are any assets or debts of the marriage that the court is going to need to. You have been able to reach any agreements as to those things. Mr. Krebs, since you're the filing party in this case, I'll ask you first. Have you been able to reach any agreements with Ms. Krebs as to dividing up any assets or debts?
Yeah, we're just gonna split everything 50-50.
Okay, and have you discussed how that's going to happen?
Yeah, we're gonna sell off our stuff. We got our house for sale currently, and then we're just gonna sell off pretty much everything we have. If not, there's a few items I'd like to keep, and I'll just pay her the half of what the value is.
All right, Ms. Krebs, do you agree with that?
Well, I do have some questions on assets. Bob started a business a year and a half ago. Is that considered part of our asset? And do we split the value of it? Do we split the tools of it? I mean, is that part of our marital assets?
So those are legal questions, and because I'm the judge in this case, and I may have to make decisions about how to divide those things up if they are part of your marital estate. I can't really answer those questions because I would be giving you legal advice about what is assets of your marriage, what is not, and perhaps how those things should be divided in it. So I understand your question. That is a question that you would have to direct to a lawyer if you wanted to get legal advice on that issue. So I think based on what I'm hearing from both of you, what I'd like to do is have this referred to mediation. And that's where you sit down with a neutral third party. That person's a trained mediator. They'll go through those kind of issues with you. They can help the two of you reach agreement. Neither of you is required, or neither of you will be forced to enter into any type of agreement, but that third party will try to negotiate between the two of you if there are any sticking points, as well as details like how much things are worth and those kind of questions. And that's a process that can happen relatively quickly. So I'm gonna refer this to the community mediation. They'll get notice that they're going to be reviewing your case. They'll contact each of you to set up a date and time that works for both of you.
Okay.
They're doing those mediations by Zoom, so you can do it remotely as you're doing it this hearing today. And then I'll set it for a hearing after that. If you've been able to agree on everything, then we can use that date to finalize the divorce.
Mhm.
If there are things that you're still not able to agree on, then we can set a date for a hearing. So then I would make the decision about how to divide things up.
Okay.
Mr. Krebs, do you have any questions about that process?
No, I do not.
Ms. Krebs, do you have any questions about that process?
No, that's great.
Okay, so after today, you'll be contacted by community mediation to set that up. You'll also get from the court a notice of the next date and time of our hearing here in court, and we'll send that out to you in the mail.
Okay.
That's all I have for today, and you're both free to disconnect at this time.
Okay,
All right,
thank you.
thank you. Thank you much.
Thank you.
Bye-bye.
All right, looks like we've got everybody connected. We're on the record now in First National Bank versus Marsh. This is case number 2311346. Mr. Kim, you're here on behalf of First National, the plaintiff, is that correct?
Correct, Your Honor. P70301, appearing on behalf of First National Bank of Omaha.
Thank you. And sir, are you Kirk Marsh?
Yes, sir.
Okay, are you representing yourself here today, or do you have an attorney that's going to be signing in?
I am myself.
Okay, all right, thank you. We're on the record here today, primarily Mr. Kim, you're on behalf of your client, you filed a motion for summary disposition. I did have a chance to review that motion. Was there anything that you wanted to say in support of that today?
Not at this time, Your Honor. Also, I don't know if I ever received a response from the defendant with regards to our motion. I don't know if the court has anything.
I did not receive a response. Mr. Marsh, did you file anything in writing in response to this motion by the plaintiff?
I did not.
Okay. That being said, Mr. Kim, was there anything else that you wanted to state for the record in support?
Your Honor, I mean, just briefly and just a slight rehash again, I mean, the defendant has admitted to all the material allegations in our complaint, other than the amount at issue. I have statements from a zero balance, which I'd be happy to forward to the defendant to show how these accounts accrued. Yeah, at this time, I don't know what the actual dispute is, other than I don't believe I all have any record of any disputes that were made to my client at the time any of these statements were sent either. So for those reasons and for the reasons stated in my brief, I'd ask for summary at this time.
Thank you. Mr. Marsh, is there anything that you wanted to say regarding this motion?
No.
Okay. All right. Based on the filings, under the court rules, Mr. Kim, the court finds that your client is entitled to summary disposition as presented in your motion and brief. And I will ask that you simply submit an order reflecting the ruling of the court today under the 7-day rule, and the court will sign that order. Given the outcome of the motion for summary disposition, I mean, this is going to resolve and be a final order. Is that correct, Mr. Kim?
Correct, Your Honor. And also, Mr. Marsh, if I may ask, please contact me to discuss this matter. Hopefully we can figure out how to resolve it at this point.
Okay, thank you. That's all for the record today. Mr. Marsh, did you have any questions before we disconnect?
No, sir.
Okay. All right, thank you. That's all for today. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you.
I'll
Have a
talk to
good
you soon,
day.
Mr. Marsh.
Okay, we're on the record in People versus Haas, case number 2211113. CF. Added an extra one. We have Ms. Koch on behalf of the people. Mr. Haas was writted for 3:15 today. I do not see anybody from Department of Corrections. This is a civil matter, so I'm comfortable proceeding. This is set as a status conference in this case today. Ms. Koch, how do the people want to proceed? This is a forfeiture action, is that right?
It is. It's a forfeiture of $202. Mr. Haas filed kind of an objection. He wrote on our complaint and turned it back in. That was before he entered a plea on this case. So I'm not really sure how he wants to proceed or how the court wants to proceed.
I think if you just want to file a, I don't know, I guess it would be a motion for summary disposition.
Okay.
I mean, this is really a legal issue, I think. I don't think there's much factual dispute about what was seized and when and all of that. It's just a question of whether the government's entitled to retain that, right?
Correct.
So I think it could be resolved by motion. So I guess that would be my suggestion if the court set aside 30 days or 60 days for you to get that motion filed and set for hearing.
Okay.
If Mr. Haas appears, we'll writ him again. If he appears, the court will consider whatever arguments he has to the contrary. Obviously, we'll consider your legal arguments and the court will make a ruling.
Thank you.
Would you like 30 or 60 days?
Let's do 60. I'm gonna be gone for a week. If Mr. Haas does show up in the next half hour, I will be here. I don't know if the court has other stuff going on.
We do, so yeah, if they pop up, then
It's likely that we can probably resolve it if he shows up based on my most recent dealings with him.
okay. Okay, thank you. That's all. Okay, looks like we have everybody connected. We'll go on the record in Swander versus Zavarro. And this is case number 2010818. Ms. Bailey Quick, you're here on behalf of Ms. Swander, is that correct?
That is correct.
Okay, and she's connected by video, Zoom, and Mr. Zavarro, are you able to hear me okay?
Yeah.
Okay. We're on the record here today. Mr. Zavarro's filed a motion regarding parenting time. Ms. Bailey Quick, you filed a motion regarding non-payment of child support. And then Ms. Bailey Quick, you also filed a request to have this case returned to front of the court. Is that correct?
That is also correct.
All right, and I should note for the record that we have Ms. Robinson from front of the court here present in the courtroom as well. I mean, it's my view after reviewing the file and given that this is going to be a front of the court case again, that this should just, both of these matters should be referred to the referee so the parties can have a hearing on both issues. Ms. Bailey Quick, what would you like to state for the record here today?
Well, it's my understanding that because support wasn't being handled through the front of the courts, that that they can't enforce the support that was to be directly paid between the parties. And because of that, I think that that's a matter that has to be handled in front of the court. That's my understanding of the case law. And if I'm wrong on that, I'll stand corrected, and certainly the court can school me on that. But that's my understanding of the case law.
All right, Ms. Robinson, do you have anything you wanted to add to that question?
Well, Your Honor, I believe Ms. Bailey Quick would be correct in the sense that for the show cause to go in front of the referee now, the front of the court hasn't been keeping track of, you know, whether he's been making payments or not making payments. So it would be hard for, you know, the referee to make a determination on that because we weren't enforcing. But as of the date that the request to reopen the case, we will then begin enforcing. But first we have to send out, we have to prepare an ex parte uniform child support order, and we have to send that out and wait 14 days. And then if there's no objections, then that will get entered, and then we'll be putting everything on the system, and then we'll be enforcing.
Okay.
So perhaps the show cause today may be more appropriate to going in front of you.
Okay.
In that regard.
Okay. All right. And I agree with what Ms. Bailey Quick, what both you and Ms. Robinson have had to say, given we're in relation to the rearages that are claimed right now. So we'll go forward with that show cause here today. Mr. Zavarro, you understand that Ms. Bailey Quick, on behalf of Ms. Swander, is alleging that you failed to pay child support as ordered by the court. Do you understand that part of it?
Yeah, well, I'd like to explain our issue here.
Well, before you make any statements for the record, I want to make sure you understand the implications, because there are potential criminal penalties for failing to pay child support. For a first failure to pay child support, you could face up to 45 days in jail. Do you understand that?
Yes.
And because there's that potential for a criminal penalty, You do have the right to have a lawyer present at any hearing. You have the right to have a court-appointed lawyer if you can't afford one. And of course, you have the right to have a hearing as to whether or not you should be found in contempt for failing to pay child support. Do you understand all those things?
Yeah.
So what you have to decide today for purposes of this hearing is whether or not you want to contest the allegation that you failed to pay child support, and whether you'd like to, hire your own attorney to help you with that, or request a court-appointed lawyer, or whether you want to admit today that you failed to pay child support in violation of the order, which again, if you do that, the maximum penalty you could face would be up to 45 days in jail. So I want to make sure that you understand those two options. Do you have any questions about those two options?
Yeah, I guess I could be appointed a attorney then.
Okay, so you want to plead not guilty to the contempt for failing to pay child support today?
Yeah.
All right, so the court's gonna, as to the allegation of contempt, and Ms. Bailey Quick, based on your filing, I think there's cause for the court to proceed with a contempt. Mr. Zavrel's pleading not guilty to that today. So I'm gonna enter a not guilty plea on his behalf with regard to a contempt charge. And we'll set that for a hearing. Mr. Zavrel, the court's gonna refer your case to Jason Thompson's office here in Grayling. He's the one that administers our court-appointed attorney contract. So I'm going to give you, before we go off the record today, I'm going to give you his phone number because you're going to want to get in touch with him. He's going to screen your case to determine whether or not you're eligible for a court-appointed attorney. Okay.
Okay.
And then we'll have a hearing on this. Ms. Bailey Quick, obviously you'll present your side of it, your evidence, and then Mr. Zavrel, the court will make a determination about whether you should be held in contempt for failing to pay child support. And Ms. Bailey Quick, how much time do you think we would need for that hearing?
I would think a half hour is sufficient, Your Honor.
Okay, so we'll set it for a half-hour hearing. And we'll set that about 30 days out. That'll give Mr. Zavrel an opportunity to speak with his appointed counsel or retained counsel. Then with regard to the, Mr. Zavrel, with regard to your motion for parenting time, the court's going to refer that to the referee for a hearing. And so you'll get notice of the date and time of that hearing, and then you'll present your arguments to the referee about why you should be entitled to different or more parenting time than what you have now. And then Ms. Bailey Quick, of course, you'll have an opportunity to contest that as well.
Very good, thank you.
All right, Ms. Bailey Quick, anything else I can address for your side on the record today?
No, Your Honor, I appreciate it. I would just encourage Mr. Zavrel, if he's ineligible for court-appointed attorney, to, just 30 days doesn't allow for a lot of time. And I know attorneys locally are very busy to just promptly look for an attorney if he's not eligible.
Okay, Mr. Zavrel, do you have something to write, a pen to write with?
Yeah, let me grab it real quick.
Okay.
Judge, while he's doing that, is FOC going to set that?
Okay.
Yes.
Okay.
Thank you.
Okay, this is the number for Jason Thompson. He's the local attorney that handles the court-appointed cases.
Okay.
And his phone number is 989 745 6625.
Okay. And his last name is Thompson?
Thompson, yep, THOMPSON.
Okay.
Okay, Ms. Robinson, anything that you needed to add?
No, I don't think so.
Mr. Zavril, do you have any questions about how we're gonna go forward?
So the next, the next date will I get in the mail?
Yes.
Okay, and that's when that's when I explain my situation, or?
You're gonna have two different hearings. You're gonna have one hearing that you'll get a date for that involves the child support issue. And then you're gonna have another hearing that you'll get a date for that involves your request for parenting time.
Okay, yeah, because I filed for the parenting time. So that will be after the child support?
I don't know, they might be at the, it's hard to say. One might happen before the other.
Okay. All right, yeah, I guess I'm all set then. So I'll just give him a call today.
Yes, correct.
Okay.
Okay, thank you. That's all for this hearing today. All parties on this case are free to disconnect at this time.
Thank you.
Yep.
Is Mr. Haas in your room? Oh, he's showing up.